By way of introduction, Associate Justice Wiebe was a practicing construction lawyer for 25 years. And I note from your bio, Associate Justice Wiebe, that you'll be 10 years at the bench this December. So we definitely have had the privilege of your judicial decisions for 10 years and the development of the law. And anyone who follows the law this year has noticed that there have been a lot of terrific decisions that have been coming out from the construction lien court here in Toronto. And I was just reminiscing the first year we were in person, we all sat together and had a lovely fireside chat. And last year we talked about how the virtual court was operating and all the hiccups and bumps and the wonderful transitions that were given to the practice bar to facilitate virtual hearings. And now, in light of Chief Justice Morowitz's decision, we are on a new frontier with possibly some new hybrid models. And so perhaps if we could kick off, the first question would be, Your Honor, how do you anticipate the lien court will change now that we have Chief Justice guidelines and the COVID restrictions are loosening? And how do you see some hearings still going virtual or in person?
Well, this is something we've been struggling with for some months now, both on the civil side here in Toronto, but certainly with Associate Justice Robinson and myself. Since His Honor released his guidelines for reopening in mid-March, we've been studying them, and it seems for the construction court in Toronto, it will not represent a huge change in the way we're doing things. And right now, as I see it, I, like you, when I fielded this question initially and thought about today, I harkened back 2 years to when we were doing things different in construction court. It was such a different world, and we'll never go back to that world again. It's quite clear about that. Going forward, based on these presumptive guidelines, I can tell you that what we'll see is really no change when it comes to trial management conferences, hearings for directions. Presumptively, they will all be in either teleconference, which is my preference, or video conference, which is Associate Justice Robinson's preference. They will remain that way. And I don't think there's even any leeway to move them into any in-person setting unless there is an overwhelming desire or expressed desire to do so. That's where they will stay. One of the bugbears of the two of us during this period of the pandemic have been these ongoing daily construction lien in writing ex parte motions. We have had to deal with them without any specific assigned time period every day, the way we used to have. If you recall back in the distant past, 2 years and beyond, we would always have ex parte court in the morning at 9:30. When it goes to 10 or 10:30, people would show up. I think that is gone. The struggle for the two of us, Associate Justice Robinson and myself, is to actually figure out whether our present system is sustainable. It's quite a challenge for the two of us because we're getting no help from the civil side. We used to get help alleviate some of the burden of these daily motions, which come in at about a clip of 3 a day. And they're all urgent and they all have to be dealt with right away. So while the volume isn't huge, it's the fact that they continue to come from all over the province, and they are urgent because they invariably involve posting security or some other urgent matter. And we used to get assistance from Master Muir, Master Short, and Associate Justice McGraw. And in the pandemic, of course, we didn't get that help. And going forward, it's not clear whether we will get any of that help. In the pandemic, we also decided, because it just didn't seem possible to have that fixed time period. We decided to simply deal with these in writings as they came in, and with the promise that we gave counsel on the bar that they would be dealt with within a 24-hour time period. And we struggled mightily every day to honor that pledge. What is the result of that is that, of course, that has impinged on our vacation time. We really can't. We find it a difficulty to get meaningful vacations. I know that everybody in the pandemic has had staycations, etc. We have had the same, but I hope that going forward, there will be a possibility of real time off. And what we do in that time period is an open and ongoing issue for the two of us. Motions. As you saw from His Honor's guidelines, these are a challenge for the court in general. These guidelines were prepared by His Honor with consultation from the bar and the judiciary, and the motions were a big part of that discussion. What do we do about them? And as you saw from the guidelines, they came down with the conclusion that presumptively they would all remain virtual, whether they were short or long motions. And what that means, but we have to respect Rule 1.08. Rule 1.08 is that new rule that specifies that when you schedule a motion, you can designate in a form what sort of form of hearing you're going to have. In-person, teleconference, video conference. You designate it, and then the other side has the right to contest that designation or accept it. That'll have to be respected in the course of scheduling motions. So there will be occasions, no doubt, perhaps with long motions, perhaps with motions like motions for summary judgment, where there will be these designations for personal hearings, and we'll have to find a place and a time to go downtown and actually inhabit a courtroom, which I haven't done really in the last 2 years. And but short of that, we are going to continue to conduct motions virtually. I always deal with them through video conference. I think Associate Justice Robson does the same. Short motions, that means we gown, and that means we go on to Zoom, and then we conduct the hearing. I don't know about the two of you, Jason and Sandra, but there may be situations where in-person motions would be appropriate. Perhaps when we're dealing with self-represented parties and they find the technology challenging, then we probably would think about switching it over to an in-person setting, and we'd have to find the time to do so. But how that gets done in a structured way is an open and ongoing discussion between the two of us. We'd like to do it in some way where we can have a whole series of in-persons on the same day, so that we would not have to always be running back and forth. We could have them designated in a certain time period for all in-person hearings by me, whether long or short, and then deal with them in person. I would go downtown to my office, and then we'd hear the motion in person there. That's still all being worked out, but that's the presumptive guidelines for motions. For trials, the presumption goes the other way. The presumption is that because we are in effect single judge trials, the presumption is that they're going to be all in person. I haven't seen the courtrooms lately. I'm being told by people that actually all this plexiglass that has been installed, it may be there, or they may actually take it down, because largely has been found that this plexiglass is useless. And but in any event, we're going to go back to these courtrooms. I'm actually going to see the inside of a courtroom. I'm going to see people face to face. How that gets done is an interesting question, because everybody will, we won't have the problems that we used to have with these kinds of trials of document management, because we all have access to case lines online. So it shouldn't be as much of a problem. But it's certainly, there will be the issue of having to have, monitors for witnesses so that everybody can see what is being projected. And, there are other little hiccups. I know that Associate Justice Robinson, who is light years ahead of me in technology knowledge, and actually has conducted now 2 hybrid trials in person. He's somebody I'm going to have to study closely. He's a hugely welcome addition to the court. I really am glad he's my partner in this at this time. So that's the general lay of the land. Now, I should make one final comment. The transition period for us is going to be gradual, obviously, because as you know, for our references, we've been scheduling trials as far out as January of 2023. And with the existing protocol, they're all virtual. They all have directed to be virtual. But I will say this to the bench, to the bar. If you wish to have your existing trial converted to an in-person trial, we are obviously going to listen to those submissions. You would have to have another trial management conference to deal with the issue, but we would certainly not dissuade you from doing so. The other side may agree with you, it may not, but we'll deal with the issue then. I don't know, what is your view, Jason and Sandra, about in-person hearings? Do you welcome them? I don't know what the feeling is in the bar. My own view is I've gotten quite used to virtual hearings, and I find them actually, after all this change, I actually don't mind them, I actually like them.
Sandra, do you want to go first on that one?
Sure. Well, I was going to say, when I would come to the 9:30 and sit, and I really appreciated listening to other people and the motions. And I always learned something and always went back with a tip on what was happening in those hearings. So I do miss that opportunity, but I do understand on the flip side, the vacating motions. And I hear that there are quite a burden to you and Associate Justice Robinson, but the fact that they get turned around so quickly with the virtual accommodations is definitely beneficial.
Okay, thank you.
I have a similarly diplomatic response in that I really do like online hearings. They're very convenient. It gets over geographical boundaries if there are witnesses or people out of town, that sort of thing. This will cuts through that quite nicely. But particularly if you're dealing with issues of credibility, a live hearing is a real advantage. And sometimes just dealing with the complexities of whether it's documents or witnesses, just being there live in the same room together assists with context. You can pick up on verbal and physical cues from people a little bit better, I think. So when things really matter, an in-person hearing is something that I'd still like to do.
Yeah. I mean, these are all factors that we would consider. I mean, I understand the credibility point, because there's all kinds of, you can see body language, which you do not see in video. Fidgeting going on in a chair. Maybe you see that in Zoom, but maybe you see the sweaty palms. I don't know. Do you? And particularly, I get the impression, having done now 6 trials, an effective cross-examiner comes across just very effectively in Zoom, just as well as in person. The uncomfortable witness will become uncomfortable in Zoom, believe me.
That is good to hear. Sticking with the theme of COVID for our next question, Associate Justice Wiebe, have you encountered any issues with the 1 month where the Construction Act limitation periods were suspended? Sandra and I were thinking specifically of the 2-year expiry period for liens, but we're happy to hear your comments.
Surprisingly, no, because everybody is very careful about factoring in that. I mean, it's 30 days as opposed to, let's say, 6 months. So that's not a lot of time. So everybody is very careful to just simply tack on that 30-day period in their submissions. For us, it's an issue because of ex parte motions under sections 45 and 46. These are motions where there is no opposition, so we have to be the grilling party. We have to be the ones to make sure that everything's, by the by. And but I can tell you that anybody who brings motions under those sections has always been very careful to make sure to wait that additional month to bring that motion, and then it has not really been an issue.
Okay, switching gears, we want to talk a little bit about joining lien and trust claims. And I have some context to the question because maybe not all audience members are fully oriented, but it will end in a two-pronged question for you. Initially, it appeared that the Construction Act would change the past prohibition under the Construction Lien Act, in that the Construction Act removed the sections from the old act that prohibited joining lien and trust claims, and the section that permitted lien claims to be joined with breach of contract and subcontract claims. So for the studious, those were sections 50 sub 2 and 55 sub 1. But then the Construction Act was amended such that the old section permitting the joining of lien claims with breach of contract and subcontract claims was reintroduced as a regulation. And again, for the studious, that's regulation 302/18, section 3 sub 2. But here's the problem. Nothing further was done in respect of the matter of joining lien and trust claims.
Right.
And, as I ask you this question, we are, of course, mindful of your decisions in Damasio Drywall and the Tapa Uric case, and also of Justice Harper's decision in SRK Woodworking in Devlin, which is under appeal. So now comes the two-pronged question. Why is the joinder of lien claims and trust claims at all an issue for the construction bar? And what might a plaintiff do if they're considering forwarding both?
Well, it's an issue for the construction bar, and it's always been an issue, and it's been an issue for the people who made the act because of the overarching desire, I think reflected in section now 50, of keeping lien proceedings in a simple and in a summary fashion. This might seem surprising to many of you when you're dealing with complex lien cases, dealing with $20 million, but that's what the general view was, because this is a cloud on title. Lien rights arise and expire, and the proceeding was always viewed to be and hoped to be summary and relatively speedy. That's why those restrictions existed under the old act. When the experts report concerning the reform came out, the legislature did remove the express prohibition and then what I call the indirect prohibition, both of them. I remember having OBA evenings with the masters where this was discussed at some length, and I may have been a bit more vociferous than I should have been about the advent of these two amendments, and because my concern was that would make, in effect, lien proceedings like no different than another regular commercial action in the commercial list. And it would make it difficult in that event to actually maintain the existing system that we had in Toronto. I just tried to envision what it would be like to run a reference where there would be not only issues of breach of lien remedies and breach of contract, but oppression, architectural negligence, maybe even family law, perhaps even, I don't know what you can imagine, a Mareva injunction thrown in. How could you run a reference or a reference trial in any efficient manner consistent with the notion of summary procedure with all these claims thrown in? And so I made that point, I think, on the evening with the masters, and perhaps the government picked it up, and they decided in the spring of 2019 to bring back section, the way I see it anyway. I have to be mindful about what I'm saying now, Sandra and Jason, because that decision is under appeal. So I'm just going to make comments in a general level. The way I saw it when I made my decisions was that it just seemed to me that the government had a change of mind. And I said that in the Topirate case and in the Damasio drywall case. I thought they had changed their minds, but they didn't reintroduce that old express restriction. I found it to be immaterial. His Honor came to a different view, and and he is the law at this point. I made that decision as only an associate justice. I did not have a reference governing me at the time. So the law of the land as we sit here today is that of His Honor. So to answer your second question, what should we do about this going forward? My advice to lawyers is to follow the old practice. Just simply start a separate trust action and a lien action. It really was not a big issue for me in the old days to have that done, because I would always tell people then to get an order of reference under Rule 54, very much of the same structure that you would have for a judgment of reference of the lien proceeding, and have that specifically referred to me. And then the matter would come to me, and I'd be dealing with both within the same reference. And I can tell you that what I normally did with those trust actions is that I would defer the truly, purely trust issues to the conclusion of the determination of the lien proceedings. And I have never, although I have done this many times, I have never had to actually conduct a trial of the trust issues, because invariably the lien actions resolved. There was often security posted for the lien, and when that report went down, there would usually be a payment, and that was the end of the issue. The trust is really a backstop. The trust action is a bit of a backstop, in an insolvency situation where you have real issues of whether you're going to be able to collect or not. But I'm giving you my personal impression. If you go the other route and you presume that there is no restriction on joinder, then you run the risk that the divisional court will come down against His Honor's decision and find that there is a restriction, and that you'll have to then, and your joinder may have been improper, which means you may have to then start a new action, and it means you need to be out of time. And why run that risk? That's my comment.
Thank you.
Sorry, Jason, it dovetails quite nicely with the next question, but I agree with you wholeheartedly on the old practice where, if we start adding personal defendants for breach of trust in a lien action, what about the limited appeal rights? What about the automatic right of no production and discovery? What about if it's a multi-party lien party and these individuals are wrapped up into an extremely complicated,
that's an excellent point.
It's the wheels of justice have automatically slowed down for those individuals. And so I can't remember, there was a case maybe 20 years ago where I think it was the surety who said, I don't want to buy into this limited fast track process.
Well, parties agree. You know how consultants have always resisted joinder of any kind to a lien proceedings. And I encounter those motions all the time on these motions to join third parties. They are always there kicking and screaming. We don't want to be in a lien action with all these restricted interlocutory provisions. And we want to have the full right to appeal any interlocutory rule. I mean, whatever. So you're absolutely right, Sandra. If you bring in all of these parties into a lien proceeding, what will become of a lien proceeding? I mean, it will simply, in my view, become another commercial action.
Right. But where exactly as you said, where parties agreed, you park the breach of trust action towards the end. That's by consent, and the process is managed to allow the efficiencies of the Lien Act. But this brings you right into the appeals and interlocutory motions. So,
well, thank goodness for Associate Justice Robinson. He is a true clear thinker, as opposed to old-time dull thinkers like me.
we've got
I'm glad he's on the bench, because he helps create and carve out these very needed clarification decisions that he makes. And his decision in GRH Asset Management, I thought was a real breath of fresh air, because it was always one of those issues that sort of lingered at the back of my mind. I mean, is it really an interlocutory step, or is it an interlocutory order, or what is it? I mean, it was, but nobody really took the bit by the horns. And I understand from that case, there was very good counsel making submissions, and that brought this issue out. And really coming out of that decision, what I would tell the bar is quite simply this: everything is an interlocutory step, short of a trial. There are sections of the Act that mandate and allow for interlocutory steps for which you do not need leave. Those are Section 45, Section 46, and if you can shoehorn yourself into Section 47, Section 47. Short of that, you'll need leave for everything, even including a motion for summary judgment, which might end up in a final order. A final order is an order that resolves finally an issue in dispute. That could be a small issue on an interim trial basis. Could be an issue on a motion for summary judgment, like as small as the timeliness of your lien. If there's a motion that ends up in a final determination of that issue, arguably that's a final order, and there you off to the divisional, I believe it's the divisional court as of right. If it's an interlocutory order, the new Act doesn't, as the old Act does, prohibit any appeal. The old Act prohibited any appeal of an interlocutory order. Now I understand you can seek leave of the divisional court to appeal an interlocutory order under the Construction Act. But that's the basic mental process I bring to bear now in light of this great decision. I know it should have been clarified earlier, but now it's clear in my mind. Does that make sense to the two of you?
Well, I always struggle with that section and the rule. And so I guess the question is, if I brought a motion for leave and I'm denied, is that a final order?
Oh boy, leave it to the two of you to really throw a curveball my way. I don't know the answer to that. I would assume that a leave application is a given of a right, as it's a right given by Section 67 or now 13, I think, under OREG 30218. So if you're denied leave on a motion which would have resulted in a final, I don't know what the answer is, frankly, to that. Has there been any decision on this point? I would assume it should be a final order then, because is it? I don't know.
Well, I guess if it depends, I guess, what the relief is. So if it's a motion for leave for an affid like production and discovery, and that's denied, I don't think that's a final order.
Yeah, that's correct.
We have a lot of brain power in the audience. So I think that's not that, because it doesn't determine it. But
let's say you want to have leave for a motion for summary judgment that you lose. You lose the leave for a motion for summary judgment. Is that a final order? No, because it doesn't resolve any issue in the case. So I would more and more, as I think about it, probably tend to be of the view that it's an interlocutory order, but that's just my view, and you'd have to seek leave of the divisional court to appeal. That's now the law, isn't it? Under Section 71, you get leave on an interlocutory matter, right?
Yes. So I envision multiple types of appeals because we don't know yet.
We don't know.
under this?
We don't know. No. Well, you guys like to throw curveballs at me.
Well, we appreciate it. It's great for discussion, and I guess I can segue into requests to admit and how a request to admit might replace or assist Scott's schedules, or how does the construction bench handle the use of request to admit?
Well, as was clear in that Volta Electric decision that came down from, I think it was Justice Carocha, he made an absolute correct decision. It's an interlocutory step that needs the leave of the court in order to do so. In all of my references, virtually all of my references, I actually mandate requests to admit. And the reason I do that is I want the parties to reduce as many issues in dispute by the time we reach trial. And this is just another vehicle to do that. And it does it in two ways. By the end of the discovery process, the answers to undertakings process, it forces the parties on pain of costs to actually really burrow down to the issues that are in dispute and get rid of the ones that are not. That's reason number one. Secondly, when they prepare their trial documents, they can then, in addition, they can basically set the groundworks for whatever documents they can admit without any major serious issue by having the parties admit them as to authenticity and admissibility. That's the second reason. And it really eliminates many of the document issues. I mean, if you have a legitimate, document issue that you want to go take to trial, that process will identify it. And in addition to my other directions, I will require the parties to highlight and give me those documents they're going to be fighting over. I have never had a trial, by the way, where I've had a contest over a forged document or, something like that, something as sexy as that. I'm looking forward to the day when I can make that kind of a determination, but it hasn't happened yet. But to answer your question about requests to admit, I think they're still useful vehicles, and it leads to the issue of admissions, which was the subject matter of one of my decisions in 2021 that I thought was interesting. May not have been interesting to the bar, but it was interesting when I wrote it because it deals with admissions, and it was admissions not made by request to admit, but admissions made in a pleading. And it's that decision that I rendered in, what was the name of the case again? It was Alumtic and Sun City. And I remember it fairly well now that I think about it, because this may be another topic you want to bring up about pleadings. Pleadings are often an overlooked area in the construction bar, and I have found a couple of occasions in 2021 that really can hurt you. You have to be careful. This was one of those cases. Let me tell you about the case. It was a case where the general contractor brought a motion under Section 47 attacking the lien of the subcontractor as having been registered or perfected too late under the old act. The subcontractor made the argument that the old act didn't apply, but the new act did, by arguing that the general contractor was not really a general contractor, but was really a partner of the owner, was really an owner. And that made the subcontract a contract. And the date of the subcontract was after July 1, 2018, thereby making the transition rule for the new lien period applicable, and that saved his lien. Well, this was all very good and very sophisticated, and he had a whole bunch of evidence about the evidence that he had put together on discovery, and indeed in the motion itself, on what made this contractor really an owner's partner. And it was a lot of work. The trouble is, in his own pleading, in about 5 or 6 occasions, he had openly and expressly identified the contractor as a contractor and called him that and said so in so many words. on several occasions and brought no motion to set that aside under Rule 51.05. And that came up in the argument, and I asked him, the lawyer, what about these admissions? And he said, well, I really hadn't turned my mind to them. And I said, well, you better, because an admission is a concession of a material fact that the other side does not have to prove. And you have not brought a motion to bring it, to set it aside. Therefore, you live with it. And I denied his motion. And it just underscores the need to be very mindful of your pleadings and also admissions. And anyways, that's a decision I remember making, and I thought was very important, because very often lawyers are not as mindful of their pleadings, in my view, as they should be.
Well, thank you for bringing that case to my attention, and I wholeheartedly agree with the importance of pleadings and revisiting them as new evidence comes forward. So if the council had amended the pleading, and
well, what
then
he should have done, what he should have done, and I told him that, at minimum, he's facing a motion under Section 47, attacking his lien because of a late perfection. And he can be saved by making that change, making the plaintiff a different party in his pleading. He should have cross-moved to amend his pleading. I would have heard that motion first, determined it first, and probably if he had, and there's a real test to set aside admissions. You have to have the explanation as to why you made the admission in the first place, which is one of the problems I had with his motion. Why do you bring this motion when you have actually no explanation why you had made this admission? And you have to have that admission, you have to have that explanation in your material, and then you have to show that there's no prejudice to setting aside the admission. That's very difficult to make, to meet in the middle of a motion when you're trying to, when the other side has actually brought a motion based on, in part, these admissions. And pleadings, by the way, is another topic that, if you want to talk about cases, I had a case that you brought up with me, that CASME case.
Yeah,
save on contract.
I was going to say you've anticipated some of these comments, anticipate that question, so we may as well go to it. I mean, that case reads like a law school exam question in some ways.
It was like a law school exam case, frankly.
Yeah, happy for you to speak on it. The question that we're most interested in is, given what you've seen, are there things that you would tell counsel in terms of drafting their pleadings, what they should be mindful of as they go through it? But happy for you to speak on the case itself.
Well, I think that's a general comment. I have to be careful because I'm seeing this case at trial in a month and a half. But the motion itself is indicative of the next comment I'll make, and it's a general comment. When you do your pleadings, be always mindful of the causes of action that you're addressing and the remedies that are appropriate for those causes of action. Always be mindful of the restrictions in the statute about what you can join. My understanding is, even with SRK and that issue, you have the right to join with lien actions, breach of contract claims, and quasi-contract claims. Quantum merit claims that are sort of quasi-contract. That's the extent of the old law, anyway. Within those parameters, you have to fit your cause of action. So you have to be careful to plead carefully and clearly what the material facts are for those causes of action, and then the remedy that you wish me to impose. Breach of contract, and this was clear in the CASME motion, can be complicated. It's normally not complicated. It's normally, and this is what we're all used to, is that, no, here's the contract, you didn't pay me, that's a breach of contract, these are the damages, and this is my lien. In the CASME matter, it was complicated because the parties in issue were all sort of partners in a business venture. The registered owners were one partner. The other partner was a project manager, and the third partner was the contractor. the constructor. And they went into housing construction projects, a series of them. And the issue was this: they had one price for those parties, for depending on which party took the responsibility for Terrian warranties and charges. If it was the owner, then the price would be A. If it was the contractor, price would be B. Well, the allegation was that the owner agreed to take on those charges, contrary to the on-whip legislation, by the way, and that's how they ran their job. And then eventually, because of Terrian, they had to change that, and the contractor had to take on those charges. The contractor did. He brought a lien. He was the lien claimant on these motions, and he brought a motion. And in his breach of contract claim, the way I could decipher it, and it was difficult to decipher because it was not well pled. The original pleading had it such that the contractor claimed he was a contractor, had an arrangement with the project manager directly with the owner. He wanted to, as I could decipher, rectify the contract by changing the price to what it should have been to be conforming to the Terrian legislation. That's what I deciphered. Got a new lawyer, and the lawyer decided, because of certain disclosures that were made at discovery, and particularly the project management agreement itself, he decided to amend his pleading to add another pleading, which I had trouble deciphering all again. But the best I could make of it was that this time, he was pleading that he was now also alternatively a subcontractor, with the project manager being the real contractor, and therefore the project manager being the one with the Terrian responsibility, not him. That's what I had to decipher in all this. And the message from all this is that your pleadings matter, because I told the lawyer bringing that amendment motion that you realize this will seriously affect your recovery abilities. If you get that motion, and if that's what is found at the end of the day, that you are in fact a subcontractor, your recourse is only for a holdback against the people having ownership of the houses. Whereas a contractor with a lien against the owner has a much more powerful lien remedy. Didn't phase him. But that just is an example of how important your pleadings are. Anyways, I'll leave it at that.
I have some sympathy for the circumstance where parties discover new facts that
That's right.
change their pleading halfway through the game. But
That's right.
At the outset, I guess, to my mind, it really is an exercise in storytelling.
Yep.
Telling and I don't mean it in a nefarious way at all, just the kind of way where you really do need to explain with some coherence, logical action, legal and moral force, the story as to why your claim should be permitted or a defense should be allowed. Absolutely,
you hit it on the head, Jason. The whole exercise of litigation, the whole exercise of advocacy is telling a story, and it's really the one thing that has dominated my time on the bench, is how much that process governs what happens. Who can tell the best, most convincing, most coherent story?
It's supportable on the evidence, I suppose.
Yeah, I mean, look, 95% of the cases that I go to trial in my courtroom don't turn on the legal points. Those are largely set. It's all largely a factual issue. And those tend to turn on credibility. And credibility has many layers, many facets. It starts with the credibility of lawyers. And lawyers who come into my courtroom, we always are testing you. And how do you determine the credibility of lawyers? Well, those people who You know, don't make superfluous arguments. Don't over embellish their position. They make reasoned arguments that are within the boundaries of what the case calls for, and act reasonably. We formulate opinions about lawyers all the time. And then you go into the particular case, the way you fashion your case, witnesses you call, how you prepare. I read a very, very interesting article the other day written by Harvey Kirsch in the Construction Law Letter about summary trials. And it's made me think. I'm not sure if I'm going to change what I do, but it made me think. You know, summary trials are largely based on affidavits, right? And he had a criticism, and it made me think it all over again. Affidavits is just one filter, really, between you and the witness, because the witness doesn't prepare the affidavits. It's the lawyers who prepare the affidavits. And you always have to bear that in mind. And so his criticism was that you're not getting the witness in an affidavit, even though they signed their name to it. And so very often the cross-examiner has to get into the bottom of that. And he described a very effective cross-examination he had on an arbitration years ago, where he went to town on the witness on just that point and actually got it to the point where the arbitrator literally threw out the affidavit. So that made me think, when you prepare, even in a case, when you come to my court, most of my trials will be summary trials. When you prepare your affidavit, interview your witnesses closely and don't put words in their mouth. And if they use colloquialisms when they tell you about something, use that in the affidavit. If you have another more sophisticated way of saying what the guy is telling you, word to word, use that person's words, because that'll come out in cross-examination. And what that tells me is, if that comes out in cross-examination, and those were the words that I see written in his affidavit, rather than the more sophisticated technical words that the lawyer would use, I'd say, wow, that's a real affidavit. I got to really read that carefully and closely, because that means something. It's not just the lawyer talking there. So there's credibility of the witnesses. Experts, my goodness. Credibility of experts are so important to so many cases. First of all, be careful about calling experts. Not every issue requires an expert opinion. It's only when you really are into an issue that I need help with. Secondly, prepare the expert, because the only reason they're in court is for their opinion. They have no real knowledge of the issues in dispute, directly. So it's their opinion. So what you got to do is remember that. And you got to make that opinion as pure and pristine as possible. So you have to paper everything you do with the expert. You have to give them all the proper foundation and the evidence to make their opinion complete and believable. And then you have to treat them like they're infected. You have to literally put them in a bubble, because all of those tangential notes, all of that, those sort of marginal points they may have made on a previous draft of a report that you didn't like, that'll come out. So that's the way I was taught. And then credibility with, I don't know, there are so many levels to this point. At this point, what affects me and what I spend most of my time with in trials is this issue of credibility. I often come away, particularly when I see the cost submissions, I come away with the view, did the lawyers here have that conversation, the very difficult conversation with their clients when these offers were being exchanged? Am I making any sense?
Plenty. Anticipating our further questions and really helping. I think all of us be better counsel. So Sandra, I'm in your hands in terms, and of course yours too, Associate Justice Wiebe. I see that we have 8 minutes left, and I don't know that we want to hog all the questions. We might want to open it up to the audience to ask a question or two. Sandra, do you want, or did you have another burning question that you wanted to ask first, or do you want to see if there are questions from the audience?
No, we can take them in the chat, or if you want to come off mute and ask your question verbally, that would be terrific. And maybe while we're waiting for that, I could invite His Honor to alert us to any cases that we might not be aware of that your court has issued, or Associate Justice Robinson have issued, that you might want the bar to know of.
Well, you asked me to think about cases that are memorable, cases that are of true note to me from 2021. There is this one case, you probably remember it, called New Generation Woodworking and RV, that ended up, I've never had a case like that. I don't think there's an appeal from that case, so I don't mind discussing it. I won't go into it in any great detail. I have never had that kind of case. It involved a case where I was a defendant of substantial means who renovated a substantial property. Basically didn't pay his wood paneling contractor, and throughout the course of the lien proceedings, hired and fired 5 lawyers. On the eve of trial, 3 weeks before the last lawyer moved to get off, I set up a motion on the eve of trial by the other side to dismiss the defendant's counterclaim and defense. To make a long story short, I heard that motion. Basically, the defendant said, "I just didn't have time for this. I think it's a waste of time. I don't care about this case." I struck out his, I've never done this, but I decided I had to do it in this case for various reasons. It's in writing. I struck out his counterclaim and set-off claim, but I kept his defense alive. On the first day of trial, he then appeared and then accused me of racism, accused me of prejudice against him because he was Jewish, and I made the statement during that motion that he was, quote unquote, one of those people, close quote. Clearly that flummoxed me. I've never had that accusation thrown my way. It was a memorable day. I took it, and I remember what happened with Master Albert. You remember the case. And so I took it seriously, as you do with any recusal motion. And I went back and checked my transcript of that day, of that motion. And what I'd actually said, and you remember this time period, was with all these government restrictions on travel. He had wandered during that motion, 3 weeks before trial. He had not appeared because he was in the Christmas time period vacation in St. Bart's and didn't have contact. And that's when I said, when he came out and said that, I said, "Oh, you were one of those people who were traveling abroad." And he denied that. He said, you didn't say that. You said you were one of those people. And I said, "No, well, I'm sorry, I'm going to deny your recusal motion on that basis." He also accused me of being anti-elitist bias, which I also addressed in the motion. But I had to write a decision, and then I ended up conducting a trial with him, literally coming in and out as he saw fit. One day he wanted the proceedings adjourned because of his golf game. It was quite the experience. And then when I rendered the decision at the end of the day in favor of the lien claimant, I found out later what he did is he did hire a lawyer. He did move to oppose my report, confirmation of my report. And during the pendency of that motion, he tried to sell the land. And then there was another motion by the plaintiff to preserve the proceeds of the litigation, which I then ordered from any future sale of the land. I've never had that kind of a case.
Oh, I'm glad Sandra asked you that question.
I was going to say, that's my weekend reading, perhaps.
I don't know if you're familiar with that. There were moments during that motion when he issued threats against me personally. And he said, I'm a very influential person and I can make your life difficult.
Oh my goodness. Wow. I knew the Master Albert case. I don't know this one.
Yeah, I included those decisions with my trial decisions called New Generation Woodworking in RV. And I've not seen any appeal. I'm just assuming that things got registered with my resolve when I made that preservation order, because that would have interfered with his sale. It was quite the time. I remember being quite, it was one of those moments you have in the course of your profession when your mettle gets tested. I've always been of the view that my job as construction master or construction associate judge is to serve the bar, serve the parties in this industry by moving things forward in an expeditious manner towards trial. And when I see abuse and purposeful delay, I get my back up.
Well, hopefully it ended up being a good story for that lien claimant. And it's unfortunate where the lien claimant has to go through all these gymnastics, but with the support of Your Honor to put it through and push it through in a timely way. So thank you very much for
well, I'm sorry, I may have preempted your time with these questions. I hope I didn't. I just thought I wanted to bring that to everyone's attention. It was one of the more trying parts of my year, but I hope it ended up where it should have ended up.